Shekma. My name is Jennifer Walton, and today I'm going to be presenting my final for the Tribal Courts class for the Indigenous People Law program through the University of Oklahoma for the summer of 2024. My presentation is titled Chickasaw Tribal Court Systems, an Overview. A quick overview of the Chickasaw Nation. The Chickasaw Nation is a federally recognized First American tribe located in south central Oklahoma. The Chickasaw Nation defines a treaty territory as being a reservation which has not been disestablished and refers to Native Americans as First Americans. Currently, there are over 80,000 enrolled Chickasaw citizens, with over 55% of those residing within the state of Oklahoma. The Chickasaw Nation's treaty territory includes 7,648 square miles, encompassing all or parts of 13 Oklahoma counties, including Bryan, Carter, Cole, Garvin, Grady, Jefferson, Johnston, Love, Marshall, McLean, Murray, Pontotoc, and Stevens. The Chickasaw Nation is led by the governor and lieutenant governor. Governor Bill Anachabi is the 32nd governor of the Chickasaw Nation and currently serving his 10th consecutive term as governor. He was first elected as governor in 1987 after serving 2 terms as lieutenant governor under Governor Overton James from 1979 to 1987, prior to being selected as governor. He was hired by the Chickasaw Nation in 1975 to serve as the Director of Tribal Health Services and directed its finance department in 1976. He was elected as the first lieutenant governor in 1979 under Governor James, and since his reign, the tribe has grown from 250 employees in 1987 to over 13,500 today. He was inducted into the Oklahoma Hall of Fame in 2004. Lieutenant Governor Chris Anachabi was elected as Lieutenant Governor in 2019. He has over 20 years of experience, beginning his career in 1997 as a staff pharmacist at the Chickasaw Nation Department of Health and was promoted to inpatient pharmacist in 1998. He was named the Chief of Pharmacy Services in 2001 and promoted to Chief Medical Solutions Officer of the Chickasaw Nation and president of the Chickasaw Nation Sovereign Medical Solutions in 2010. In 2018, he was named the Deputy Secretary of the Chickasaw Nation Department of Health. Before we can understand our tribal courts today, we must first learn the history of what made our Chickasaw Nation government. That begins with the Treaty of the Chickasaws, 1834. This treaty's goals was focused on peace, amity, and friendship between the United States government and the Chickasaws. This was a removal era treaty that discussed provisions towards Chickasaw relocation to the new homelands west of the Mississippi River. The United States agreed to protection of other tribes. The U.S. agreed to protection of the tribe from whites and other tribes during relocation. The Chickasaws agreed to no wars between the United States and other tribes unless given authority to do so by the United States. The Chickasaws were allowed to protect themselves and their resources from attacks during the relocation and were not bound to U.S. laws as they predated the Constitution and are subject to their own laws and jurisdictions. Chickasaws had the rights to control their own affairs without government involvement. The treaty also lists provisions for reservation terms for families, including families of 10 or more people being allotted 4 sections of land, while those with 5 to 9 were given 3 sections and less than 5 were given 2. Owners of 10 plus slaves also received an additional 1 section, while those that owned less than 10 received an additional half section. The treaty also included educational opportunities for Native children, The government shall appropriate $3,000 for 15 years under the direction of the Secretary of War for education of Chickasaw children. Finally, the Chickasaws would cede their former reservation to the United States, located east of the Mississippi. The land was to be reimbursed at $1.25 an acre, and the title of land was to be relinquished to the United States. Chickasaw government began with clan systems before the development of our government, what it is today, but started to fade with European contact in the 1700s. At the time, Chickasaws were operating under a developed code of written laws until upon their removal in 1837. The laws were abandoned when the Chickasaw Nation was placed as a district within the government of the Choctaws and Indian Territory. Unhappy with this arrangement, the Chickasaws searched for a form of separation from the Choctaws and was granted that by a treaty in 1855. Chickasaws gathered in 1856 at Good Springs on Pennington Creek in Tishomingo, Mississippi, to draft their own constitution. The Constitution consisted of a three-part system of government, including executive, judicial, and legislative, that was reflective of the United States government. This Constitution served the Chickasaw people until dissolution of tribal government and preparation of Oklahoma statehood in 1906. In 1971, the first tribal election was held in Oklahoma, which was vital to the development of Chickasaw Nation and its tribal government. The Constitution was ratified in 1983 and amended in 2002. The Constitution includes a preamble and 21 articles. Within the preamble, it allows the Chickasaw Nation to be permitted to make their own choices for their own form of government in accordance with the first, second, fourth, and seventh articles of the treaty between the United States and the Choctaws and Chickasaws of 1855 and the treaty in 1866. The preamble lays out the boundaries of the Chickasaw Nation. I'm now going to go through a brief overview, I hope it's brief, of articles contained within the Constitution. The Article 1 discusses the establishment of the name of the Chickasaw Nation. The Article 2 discusses citizenship. It discusses assigns powers of citizenship to the Chickasaw Nation tribal legislator to enact ordinance governing future citizenship as well as the loss of citizenship within the Chickasaw Nation. Article 3 discusses the rights of suffrage, and it allows all citizens 18 and older the right to vote in tribal elections. Voters must be Chickasaw citizens and not members of other federally recognized tribes to be allowed to vote. Article 4 discusses the Bill of Rights, and the Constitution shall not interpret it in a way to change individual rights of tribal members as tribal citizens, state citizens of Oklahoma, or U.S. citizens. All political power is inherent to the people, and all free governments are founded on this authority and instituted for their behalf. Tribal members have the inalienable right to alter, reform, or abolish their form of government in such a manner as they feel best provided, according to the Constitution. No religious tests will be demanded for those taking office of the Chickasaw Nation, and all citizens are free to practice their free rights of speech, and they're able to meet for the common good. Jesus. Article 5 discusses the division of powers of government, which reflects the layout of the United States government with the three branches: legislative, executive, and judicial. The offices of the Chickasaw Nation are to be held by elected officials. Article 6 discusses the legislative department, which will be the power vested to the Chickasaw Nation tribal legislator. Members of the tribal legislature must be Chickasaw Nation citizens and residents of the Chickasaw Nation for 1 year and of their respective district for 6 months immediately preceding their election. Upon election, they must remain residents of their district during their term and registered to vote and must be 25 years of age or older. Tribal legislature is composed of 13 members from the Panola, Pickens, Tishomingo, and Pontotoc districts, and members cannot be convicted of a felony. Article 7 discusses privileges, duties, and powers of the legislative department, including the roles of those elected to tribal legislature. Article 8 discusses sessions of tribal legislature, which are to be held monthly and where, and requires the mandatory attendance of at least 9 members to constitute a quorum. At any time, governor can call a meeting by identifying members within 24 hours notice, and all sessions are open to the public. Article 9 discusses order of business and the topics discussed during each monthly session. Article 10 discusses executive department. Supreme executive power is vested to governor, and lieutenant governor will assist governor and perform all duties assigned. Both positions are assigned to 4-year terms and can be held by anyone 30 years of age or older who is at least 1/4 Chickasaw. Both positions must be registered to vote and must be Chickasaw Nation citizen residents a year prior to their election and must remain residents through their term and cannot be convicted of a felony. Article 18 discusses privileges, duties, and powers of the executive department. The governor shall perform all duties pertaining to the office of chief executive and sign all papers pertaining to the Chickasaw Nation. He has the power to establish and appoint committees, members, and delegates to serve the Chickasaw Nation with tribal legislative support. At any time, he can veto legislative decisions, but tribal legislator can also override his veto in accordance with Article 7, Section 9. He'll prepare and submit an annual budget to tribal legislator, and the lieutenant governor will serve in the absence of the governor. Article 12 discusses the judicial department, which will consist of the 3-member court elected by popular vote of Chickasaw Nation voters. Members of the judicial department must be qualified electors, residents of the Chickasaw Nation, and residents of their office. Tribal judges are elected 3-year terms and shall serve until their successors are duly elected and installed. The 3 judges shall select the preceding judge amongst themselves annually, and the members of the judicial office cannot be convicted of a felon by a court of competent jurisdiction. Article 13 discusses privileges, duties, and powers of the judicial department, including the judicial department's jurisdiction to decide disputes by a vote of 2 members. Decisions of the judicial department are final, and tribal judicial department shall have jurisdiction to hear claims regarding malappropriateness. Article 14 discusses the initiative petition and must be signed by at least 20% of registered voters of the Chickasaw Nation. It should be conducted and prescribed by tribal legislator, and the passage of these propositions shall require a majority of votes of at least 30% of registered voter ballots. Article 15 discusses vacancies and how to fill those in the case of death, resignation, impeachment, or recall of the governor, upon which lieutenant governor shall immediately become governor for the rest of the unexpired term. The chairperson of tribal legislator would step into the role as lieutenant governor for the unexpired term, and tribal legislator will elect a new member from leadership to serve the role as the chairperson. Article 16 discusses impeachment and recalls of officials and the processes taken to impeach and how to fill those roles of those who are removed from positions. Article 17 discusses the oath of office taken by elected and appointed officials. Article 18 discusses amendments to the Constitution. 19 discusses effective dates of Constitution, which are effective when approved by Secretary of the Interior and ratified by the Chickasaw people. Article 20 discusses the approval process. Article 21 discusses certificate of ratification. And the Constitution ends with the amendments to the Constitution, which to date are 6, with the last being made in 2002. Now that was a lot to go through, so here's a quick breakdown of all of the articles for fast reference. We'll now discuss the history of tribal courts, which is important to discuss both pre and post IRA. Pre-IRA begins with the Treaty of Oldtown, which discusses the beginning of the Chickasaw Nation within Oklahoma. It was signed by tribal leaders and ceded lands in western Kentucky and Tennessee. Chickasaws in 1826 refused to cede their lands, which is important as it along with the following two bullet points of the election of President Andrew Jackson in 1828 and the passing of the Indian Removal Act in 1830 foreshadowed the Chickasaw removal. Post IRA, there's a lot of events that happen with that. It begins in 1834 with the Treaty of Washington, which followed Congress's failure to ratify the Treaty of Pontotoc in 1832. Chickasaw leaders agreed to confirm their land for money exchange by signing the Treaty of Washington in 1834. In 1837, the Treaty of Dopesville gave Chickasaws the rights to settle in the western part of Choctaw lands in Oklahoma. Choctaws leased their lands to the Chickasaws for $530,000. Chickasaws also elected a chief to the Choctaw Council, but even though they did this, they still continued to practice their ancient system of kings and clown system councils. In 1837, 80% of pre-removal population of Chickasaws relocated to the new homelands. 1842 and 1842 and 1851 saw both the construction of Fort Washita and Fort Arbuckle, which are important to note because even though these forts offered security to the Chickasaws, relocation still took Chickasaws 15 years to complete. 1846, we see the General Council set up at Boiling Springs, followed by 1849, the Committee of Vigilance was established. The Committee of Vigilance established means that tribal external affairs were managed in a manner that hadn't existed before. We continue in 1854 with Choctaw and Chickasaw commissioners reaching agreement of separation. Both sides had decided that separation was necessary. They both wanted to form their own forms of government, and it just was not working with them both relying on one type. On 1855, they get that through a formal separation treaty finalized in Washington, D.C. And in 1856, that was ratified by both tribal councils and the U.S. Senate. This brought about in 1856 the emergence of a new Chickasaw Nation with a new constitution, and this constitution guaranteed the essential principles and individual rights of a free people and government. In 1861, the Chickasaw Nation declares independence and joins the Confederacy. This we know causes problems, and the Chickasaws make this decision based on bitterness of the United States over land sales, causing the Chickasaws to decide to ally with the South. The war ultimately ends in 1865 for the Chickasaws at Fort Smith, and in 1866 they are summoned to sign the forced treaty renewing compact with the United States. This is also not good for them. It's kind of their punishment for fighting for the South Confederacy. And in this renewing compact, they agreed to abolish slavery, recognize the rights of freedmen, and provide all railroad right-of-ways through their Indian country. So through the 1856 new constitution, several things come into light, including the separation of powers into three branches of government: legislative, executive, and judicial. There's a council to legislative body, including a House of Representatives and a Senate. And the Judiciary Department now includes the Supreme Court, circuit boards, and county courts. The tribal chief is now promoted to governor and elected by popular vote to a 2-year term. Essential principles and individual rights are given to the free people and government. The structure of local county government is defined, and slavery is protected. In 1866, a new constitution is created, and it eliminates slavery, recognizes freedmen, and increases Chickasaw economy and political life. In 1895, through the Dawes Commission, hearings are held in Indian Territory to negotiate allotment agreements with the 5 tribes. The tribes were not for losing their land, and so in 1906, there was an abolishment of tribal laws and government due to the Curtis Act, which tribes originally, through the Atoka Agreement, had not wanted any part of it. But through the Curtis Act, it embodied the Atoka Agreement and ended tribal sovereignty, abolished tribal courts and enforcement of tribal laws, and scheduled termination of all tribal governments. In 1907, Oklahoma reached statehood. This made Chickasaws a powerless minority, both in the tribal lands and in the state of Oklahoma. And from 1907 to 1983, the Chickasaw Nation pretty much fails to exist. And although this happens, this does not mean that things are not occurring behind the scenes. The office of governor continues through presidential appointment. Chickasaw governors and tribal attorneys become involved with issues relating to jointly owned coal and asphalt lands and other unresolved land questions. In the 1930s, we see the New Deal legislation as well as World War II and post-war periods, which bring about changes to the lives of the Chickasaw, including funds for education, relief in jobs, election of tribal council, and a renewed sense of Indian identity. The 1960s bring about a shift in federal Indian policy. We see from termination to self-determination and Native American rights activism. It spurs political and cultural rebirth among Chickasaw people. In 1963, under the leadership of Governor Overton James, the Chickasaw Nation begins to take advantage of federal programs to provide social and economic services to tribal members, which is huge. In 1971, Governor James becomes the first elected governor since 1904 under the Indian Civil Rights Act of 1968 and other federal legislation that restored the rights to hold popular elections. The Chickasaw Nation then adopts a new constitution in 1979 based on the old 1866 constitution, which separates the powers into three branches of governments. In 1983, it's considered the rebirth of the Chickasaw Nation. Chickasaw tribal members ratify a modified version of the Constitution that received approval from the U.S. government in 1983. Governor Anna Tubby is elected in 1987, and as of today, the Chickasaw Nation provides a multitude of over 200 plus programs and services for Chickasaw citizens, both within the treaty territorial boundaries and at large. Chickasaw current tribal court laws are a big part of those rest within the Chickasaw Code, which includes regulations and laws vital to the day-to-day functions of tribal government. It provides Chickasaw Nation officials and employees a framework for maintaining highest standards of personal conduct and services to Chickasaw people. It has 21 titles, including utilities, safety and law enforcement, real and personal property, lands and natural resources, the governor, finance and taxation, courts and procedures, and domestic relations and families. I have provided a hyperlink if you would like to follow that within the slide to view the Chickasaw Code and learn more about it. Now I'm going to start talking about the Chickasaw Nation tribal courts. I'm going to start with the Supreme Court. The Chickasaw Nation Supreme Court settles disputes involving provisions of the Chickasaw Nation Constitution and laws. The Supreme Court has full authority of district court appeals to affirm, reverse, modify, or vacate any action in the district court or other entity as authorized by law. The Supreme Court consists of 3 Supreme Court justices elected by popular vote of qualified voters for the Chickasaw Nation. The judicial power of the Supreme Court extends to all cases arising under the Constitution, laws, and treaties of the Chickasaw Nation, and to all controversies to which the Chickasaw Nation shall be a party. The judicial building is located at 812 North Mississippi in Ada, Oklahoma. And the 3 Supreme Court justices are Mark Holmes Colbert, Linda English Weeks, and Sherry Bellefue Gordon. The Chickasaw Nation District Court is comprised of both a special and district judge, as well as a court advocate appointed by the Chickasaw Nation Supreme Court and was established in 2001. Responsibilities include presiding over all First American civil action family law issues, such as divorce, parental rights, child custody and support, visitation, juvenile and civil matters, adoption and guardianship, and criminal offenses committed by First Americans or non-native offenders who commit crimes of domestic violence against First Americans within its boundaries. The district court may also be assigned responsibilities by legislative or executive order. The Chickasaw Nation assumed primary responsibility for the operation of the Chickasaw Agency Court of American Indian Offenses Code of Federal Regulations, or CFR, in 2003. A memorandum of agreement was assigned by Governor Anna Tubby and a designated United States representative acting through the BIA, Eastern Oklahoma Regional Director for the Secretary of the Interior. Effected in 2004, the Chickasaw Nation Judicial Department, by and through the District Court, assumed full jurisdiction of all current and future CFR caseloads. All decisions made by the District Court are recognized by state and CFR courts. The Chickasaw Nation Peacemaking Court, a division of the District Court, is a forum for resolving conflicts using Chickasaw traditions, customs, and culture. Cases are assigned to the peacemaking court by the district court or through a consent of all parties involved. The Chickasaw Nation Office of Tribal Justice Administration, or OTJA, including the probation office, serves as the office of prosecutor and exercises authority in prosecution in Chickasaw courts. The Chickasaw Nation OTJA ensures compliance with Chickasaw Nation code provisions and cooperates with other prosecution authorities. The court is designed to assist Chickasaw people, but it also accepts others into the court upon execution of certain waivers. The court will incorporate traditional values into the system to provide a more personal touch to its solutions on matters brought before it. The district judges are appointed by the Supreme Court and serve a 3-year term of office, beginning upon the date of their confirmation until his or her successor takes office, unless removed for cause by death or resignation. The district court judges are Deanna Hartley Kelso and Brett Morton, and the district court is located at 821 North Mississippi in Ada, Oklahoma. The Chickasaw Nation Peacemaking Court is a forum for resolving conflicts using Chickasaw traditions, customs, and cultures as the basis for finding peace and resolution. The Peacemaking Court is a division of the Chickasaw Nation District Court and is a process that requires the parties to agree to peacemaking and the selection of peacemakers in order to participate in the process and resolve differences. The core values of the Peacemaking Court are respect, humility, compassion, spirituality, and honesty. No value carries more significance than any other, and participating in the circle process indicates acceptance of these values, both in word and action, and a commitment to move forward with the point of dispute. There are currently 6 peacemakers within the Peacemaking Court. The Chickasaw Bar Association was established in 2003 with the first 25 members being charter members of the Bar Association. There are currently close to 600 members of the Chickasaw Bar Association. To become a member of the Bar Association, an attorney must fill out the bar application and complete an oath in the presence of a clerk, judge, or justice of the Chickasaw Nation. Only licensed attorneys in good standings with their state bar are allowed to join the Chickasaw Nation Bar. Only Chickasaw Bar Association members are allowed to practice before the Chickasaw Nation courts and commissions. The Chickasaw Nation Bar Association has been an important part in mandatory continuing legal education that is mandated by most state bar associations. The Chickasaw Nation Bar Association offers biannual legal education seminars throughout the Chickasaw Nation for members and non-members with notable speakers and presentations. If you would like to learn more information, there is a hyperlink included on this slide to learn more about Bar Association information. The Chickasaw Tribal Legislature is structured much like the United States Legislature, with scheduled sessions, committees, the formation of procedures and regulations, the approval of budgets, and the establishment of law. It is composed of 13 members from 4 districts, including Panola, Pickens, Pontotoc, and Tishomingo, and members must be 25 years old, Chickasaw citizen, and registered voter who's lived in the Chickasaw Nation for at least 1 year and their district at least 6 months prior to term. They must remain in their districts throughout their term. Tribal legislative members include Shanna Tate Darter, Connie Barker, J. Lisa Ensign, Lisa Billy, Beth Alexander, Dr. Karen Goodnight, Nancy Elliott, Scott Wood, Toby Perkins, David Juarez, Des Monatachi, Charles Maris, and Derek Pretty. I'm going to finish my presentation with a discussion of the Chickasaw Nation Light Horse Police Department. The Chickasaw Nation Department of Interior includes various programs, including benefits, human resources, self-determination, organizational planning, support, and training. All Chickasaw Nation law enforcement offices are now under the Office of Tribal Law Enforcement. The Chickasaw Nation's law enforcement offices, known as the Chickasaw Light Horse Police Department, or LPD, were established in 2004. LPD exercises the Chickasaw Nation's authority to arrest, investigate, ensure compliance with Chickasaw Nation criminal code provisions, and cooperate with external policing authorities. The LPD is led by a commissioner and a chief of police and currently consists of 105 full-time sworn law enforcement officers and 24 supporting staff. It's comprised of 3 divisions: patrol, criminal investigations, and administrative services, as well as 5 specialized teams, including SWAT, dive, peer support, honor guard, and K9. The LPD also provides support to surrounding community law enforcement to better serve all individuals within the Chickasaw Nation. The term light horse is a historic name given to the 5 civilized tribes to their mounted police force. Once removed to Indian Territory, the 5 civilized tribes created the elite Light Horse Police Department to serve and protect their citizens. LPD was reestablished in 2004, and before this, law enforcement duties for the community were performed by the Bureau of Indian Affairs. Light Horse Police Department's jurisdiction covers the entirety of the Chickasaw Nation's treaty territory, and according to the U.S. Census Bureau, the total population for the Chickasaw Nation service area exceeds 300,000 residents. LPD is divided into 3 precincts, including Windstar, Ada, and Newcastle, where the 105 full-time sworn law enforcement officers serve the Chickasaw Nation. If you have any questions or require further information, please check out the Chickasaw Nation's website at www.chickasaw.net. Thank you for viewing. Have a good day.